Hi, it's Mike DelSignore, Massachusetts OUI defense attorney. In today's video, I want to talk about the penalties for a second offense OUI. And I'm going to break this into two parts. First, I want to talk about the license consequences, then I'll talk about the penalties in court. First, let's deal with the license consequences. If you take a breath test and you're over 0.08, you're facing a 30-day suspension. So that's simple. If you refuse a breath test, you're looking at a 3-year suspension based on the refusal. So if your prior offense is within 10 years, you're going to need to do one of two things. Win the refusal appeal, which is very difficult and unlikely in most cases, or two, win the trial. And that's the more realistic avenue to get your license back prior to the 3 years. So there's no quick way to get somebody's license back on a second offense when the two offenses are within 10 years. You need to win the case, and if you win the case, the judge then has to allow a motion to reinstate. If the judge does, you can get your license back prior to the 3 years expiring. If you then admit to the charge and your OUI offense is within 10 years, you're going to face an additional 2 years suspension. But after the 3 years, you're eligible at least to try to get a hardship with the Board of Appeals. You'd have to get the interlock device in your car. Now, let's say the OUI offenses are outside of 10 years. So you got an OUI, but your last one is a long time ago, but it's more than 10 years. So in that case, if you resolve the case, you can potentially get a hardship license, but you're going to have the interlock in your car for 5 years. Now, it's not a guarantee you're going to get a hardship license right away. The registry has been a little tougher on these, but you should be able to get a hardship in most cases with the registry. If not, the board would probably give you a hardship license. But you have a path to getting your license back much quicker if the OUI offenses are outside of 10 years. Now, let's talk about the criminal penalties. The criminal penalties on a second offense, when it's within 10 years, the minimum sentence the judge can give is what they call a 14-day inpatient program. So you got to go to Tewksbury, 14 days. You can't leave there. You're not going to have your phone. You're going to basically have to do the program. And that's going to be a substitute for a jail sentence. You'll then do an aftercare program as well. If your two offenses are outside of 10 years, then you could get a resolution where you get the 24D program again, and what is referred to in court sometime as a Cahill disposition. So you might hear that terminology. That's what it means. It means your OUI second is going to be treated as a first offense. But what do I generally want to do in these cases? My main goal is to help people be found not guilty. I want to try to help you avoid the consequences, because either way, in either scenario, you're looking at getting an interlock device in your car. So if you can avoid an OUI conviction, that's the best choice. Take the case to trial. These are subjective cases. They're crimes of opinion. So breath test evidence, it doesn't always come into evidence. Keep in mind that I challenge the breath test evidence routinely. Within the last 6 months, I've had 3 clients, breath test cases. Breath test came in three of the cases came in evidence. Clients still found not guilty. These were cases in Lynn. I had another case in Brockton. So don't be afraid of breathalyzer evidence. Don't assume you can't win the case. If there is no breathalyzer, then it's an observation case, is what we say. The officer is going to say, well, I thought you were under the influence because your eyes were bloodshot glassy. You were slurring your speech. You're unsteady in your feet. But officers vary in how they testify in court. So you're going to get a report, and you're going to probably see a lot of bad stuff. I'm going to look at the report, and I'm going to tell you that what I probably will be able to get the officer to say on cross-examination, and how I'll be able to show reasonable doubt that this isn't such a clear-cut case. These field sobriety tests that you took, they're not accurate, they're not reliable, there's some inaccuracies with them. You could have medical conditions that explain balance problems. We can call witnesses. Today I spoke to somebody who I think would make a really good witness in a case. And it's not often, a lot of times people, friends, family members you might have been with don't make good witnesses. But in this case, I did have somebody that was tremendous. I thought was going to be a terrific witness. So I'm going to talk to your witnesses, and I'll evaluate whether they're going to help the case. Now, a lot of times your friends or family members, they may be nervous, they might not be that articulate, but if we can have somebody who's going to be solid on the evidence, who we're not going to have to worry about getting nervous or contradicting themselves. I can potentially call them as a witness in the right case, in the right situation. Pretty much all they need to get right is how much you had to drink, over what period of time you were there, and that they didn't think you were impaired. So they're not on the stand for hours or days. Some people think that if they have to testify, it's going to be a long process. Generally, a witness who's with you is probably going to be on the stand for 7 minutes, if that, 7 to 10 minutes, maybe less. There's very few questions, and they're a small piece to the puzzle, but they're sometimes it's what I need to be able to say that there's reasonable doubt. Hey, there's a person that came into court who gave you contrary evidence. If you have contrary evidence, that could create a reasonable doubt. So in some cases, I don't need any witnesses. I'll cross-examine the officer, establish a reasonable doubt based on the officer's testimony, based on the report, based on my cross-examination. In some cases, the evidence might be a little stronger for the government. Well, maybe that's not quite enough, or maybe I just want a little more to argue in closing, so I can say, not only did I get the officer to say that these tests are inaccurate, that the subjective people could have problems with these tests for reasons other than alcohol, but I also have this other person, judge, that came into court and said they didn't think my client was impaired. So second offense OUIs, keep in mind the license consequences can be very significant and severe. You can appeal the refusal. You only have 15 days to do it. You got to go to the R&B in Boston. Those appeals tend to be difficult to win, but I have won many of them in the past. But the primary way to get your license back is through a not guilty finding. So if you have questions about a second offense OUI, the penalties, anything about it, feel free to contact me. My name is Mike DelSignore. Call, text anytime. My passion is helping people get their lives back together after an OUI case. You can reach me at 781-686-5924.